Thank you very much, Mr. Rao, and thank you to all the participants for joining today's session, which is primarily on data protection and Information Technology Act, and also about electronic contracts and how the IT Act governs it. Today I'm joined by my colleague Nilanjana, who will be primarily taking you through the various aspects of the two issues. As you probably know, India does not have a separate law with regard to privacy or data protection. So our primary source of finding out what rights we have are from the Information Technology Act, which obviously deals with only electronic data. But as my colleague Nilanjana will explain, the way electronic data has been defined, in today's day and age, almost all data, including data which is physical copies which is scanned and uploaded into a computer, will effectively be considered as data or electronic data within the meaning of the Information Technology Act, and therefore gets protection under the Act. There are some specific rules that we'll cover today, including the 2011 rules with regard to sensitive personal data or information, SPDI as it's typically called. So there are certain types of information which get specific additional protection by virtue of them being of a sensitive nature, password, health-related information, for example, and some others, and Nilanjana will take you through the details. We'll talk about also the contracts and how the law of contracts has been given a completely different perspective in light of the Information Technology Act, and how a contract can actually be now formed without people having to physically meet and sign documents like we had to in yesteryears. It also has its downsides. For example, if there is an email that you receive and you send, if there's an auto response that goes out, that can potentially be can potentially form a contract. So there are obviously issues with regard to that, and Nilanjana will deal with that as well. The session will be approximately for an hour, after which we'll be very happy to take any questions that you may have. Over to you, Nilanjana.
Thank you, Indranil. This is Nilanjana, and I'll be taking you through the whole presentation for the next 1 hour. So the topic is data protection in India and other allied issues. Now, data protection is basically, the Constitution of India acknowledges the right to privacy as one of the important fundamental rights, which you can see, which is emanating from Article 21, which is right to life and personal liberty. Now, data protection is also a form of privacy, which is subjected to protection. And in the era of technology, with the rapid use of internet and transfer of various information or data through the new cloud technologies, sometimes the data privacy and the data protection comes at stake. So in the background of such situation, the lawmakers decided that there needs to be a greater attention given, and therefore new laws or regulations needs to be framed to protect and regulate the data protection. Therefore, the data protection, the concepts of data protection and the data privacy has been acknowledged and introduced in the Information Technology Act 2002. Now, what is data protection? In general parlance, we understand that data protection is a set of privacy laws, policies, procedures, and regulations which aim to minimize one's intrusion into one's privacy, which may be caused by dissemination of personal data or through collection, storage, or tampering of personal data. Now, as per Section 2(1) of the IT Act, data is the representation of following ingredients, that are the information, the knowledge, the facts, the concepts or instructions, which is prepared in a formalized manner and which is intended to be processed in a computer system or computer network. Now, this data may be in various forms, including if you are storing it internally in your own shared drive, or in your own system, or if the data or the information is stored in a mail ID of your personal mail IDs, or in your inboxes. So any such storage through an computer system or through an electronic network is known as data as per the IT Act. Now, as per section 21V, IT Act has defined information. Now, information also includes various items, which include, it may be a text, images, it may be sound, message, and also information includes that in its definition data. And information also includes things like voice, computer programs, softwares, microfilms, or any computer generated information data. So these includes everything comprises of information under the IT Act. Now we'll be discussing about the regulatory framework for data protection in India. So data protection is ideally acknowledged in IT Act through various rules and regulations. One of the important rules which have been framed under the IT Act is Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules, which in short it's known as SPDI rules. Now, earlier, before coming into force of the 2011 rules, it was seen that there is no specific privacy-related regulation in India. The IT Act defines and recognizes data protection. It recognizes the what is known as information, what may result in the what may result in the hampering or the tampering of information, but as such there was no proper framework which catered to the problem of privacy related issues. Now, in the absence of that, the lawmakers thought of formulating a new regulation which will completely cater to the needs and issues relating to sensitive personal information. And in this background, the SPDI rules came into force to implement this problem. Now, as per Rule 3 of the SPDI rules, information relating to certain things is considered as sensitive personal data or information. These includes passwords, financial information such as bank accounts, credit card, debit card, or other payment instrument details, the physiological and mental health conditions, sexual orientations, medical records and histories, biometric information, any detail relating to any of the above provided to a body corporate for providing services, and any of the information received under the above by any body corporate for storing, processing, or using it under any lawful contract. So the informations that we provide to any body corporate through various business transactions, for example, if we take a health insurance from a insurance company, generally we have to give some medical records and histories as a client before the insurer company decides to give a person a health insurance. So all these records and all these histories which we provide through a mutual contract, and we send it to the party in contract, and the information which is stored in their database, that is known as the sensitive personal data or information. And under the 2011 rules, they have tried to cater to the problems or the issues which might come up relating to the hampering of this personal data or information. Now, Rule 4 of the SPDI rules mandates body corporates to have a privacy policy for handling or dealing in personal information which includes sensitive personal data or information. Now, the sensitive personal data also includes records such as financial statements. Now, information such as financial statements or information which have high business implication for an organization. Those are one of the critical information which is stored in a company's database. Now, this rule, 2011 rules, they have tried to protect and safeguard those kind of informations too. Also, there are lot of times within an organization, there are various business calls which are taken within the organization by its various employees or various managements. So these informations in the technological era, like today, everything is stored in a soft copy, in a database or a data system. So these 2011 rules have also tried to safeguard and protect such kind of information from being disseminated to the persons to whom you are not supposed to disseminate those informations, and likewise. Now, Rule 5 of the SPDI rules also requires the body corporates to obtain consent in writing from the provider of the sensitive personal data or information for the purpose of usage of such information further. And also, therefore, the information which is collected from the third party by a body corporate or attract certain compliances and due diligence on part of such body corporates. For example, suppose if I take an example of a hospital or a research center. So a lot of times those establishments like hospitals or research centers, they have their own biobanks and blood banks where they take up cells or they take up blood samples from its patients or from a third party. And now in a technological stage like today, these are often even if they are taking the samples or the bloods, everything is documented and everything is barcoded in a software which is kept by the organization. Now the data which is put in such softwares, those are personal sensitive data and information which such establishments are barred from disseminating to any other party. So this act also imposes an obligation on such establishments to have a very strict and stringent privacy policy so that none of the informations go to the wrong hands. Now, Rule 6 of the SPDI rules also mandates body corporates to require prior permission from the provider of such information before disclosing it to any third party, unless such disclosure has been agreed in contract between the body corporate and the provider of information. So therefore, every time whenever any information is being given by a provider to a particular body corporate, it is the duty of the body corporate to ensure that consent, proper written and expressed consent, is taken from the provider of information, so that in case the personal information needs to be given to any third party, a proper safeguard can be shown that a proper consent has been taken, or something which is disseminated is not given in contravention to the laws and regulations stated for this issue. Now, one exception regarding the Rule 6 of SPDI rules is that where a sensitive personal data or information is disclosed to the government agencies without obtaining prior consent from the provider for the purpose of verification or identity or prevention or detection of any cyber incidents or punishments, in such situations prior permission may not be taken. For example, in cases of any court orders or during litigation for collection of evidences, in such situations, if the government body is giving an order which one needs to execute, in such scenarios you may disseminate the information, the personal data information, without taking the prior consent from the provider of information. Now, Rule 8 of the SPDI rules requires a body corporate to have complied with the reasonable security practices and procedures. For example, there is an international standard on information technology security techniques, information security management system. So there are some international standards which each and every body corporate have to comply with while they are formulating any policy on the security practices. Now, the intermediary rules also lays down certain due diligence and obligations which are required to be observed by the intermediaries in relation to the data protection. Now, Rule 3 of the intermediary rules states that mandatory publication of rules, regulations, privacy policies, and user agreements needs to be presented in the intermediary's computer resource. So the user agreements which generally the intermediaries provide must contain clauses relating to restrictions from hosting, publishing, or uploading information. For example, whenever intermediaries includes providers like Facebook or Twitter or any other e-commerce websites like say Amazon. So whenever any third person is entering into their intermediary platform, before that, so we have seen that while signing into a new account in a Twitter or a Facebook, there often comes a host of terms and conditions which the user has to agree to before entering into that platform and use it. Now, in practical purposes, normally we don't read the clauses and the terms and conditions, and we directly hit the button agreed and we enter into the intermediaries platform. But from the legal perspective, the terms and conditions which are provided, that are nothing but the user agreements of the intermediaries, which has been which needs to be obliged by the intermediaries, because it is a because legally they have to do it, because the rules the intermediary rules expressly provides that user agreements should also should be there, which is basically another way of ensuring that personal data or personal sensitive data is not disseminated without the consent of the provider. Now, the user agreements of the intermediaries must contain clauses such as few restrictions which needs to be complied with while hosting or uploading any information. Like, for example, if any information is belonging to another person and you do not have the right to upload it without their consent, such information cannot be hosted in the intermediaries platform. Or any information which is grossly harmful, or it has the potential of defaming some person, or it may harass some another person's privacy, or infringes any patent, trademark, copyright, or any other intellectual property rights, or impersonates another, those kind of informations cannot be uploaded or cannot be hosted in the intermediaries platform. Now, as an intermediary, one must also take the reasonable measures to secure that its computer resources and information content should not contravene with any of the rules or compliances or any provisions of SPDI rules. So basically what we understand that whenever any business call which is taken by an intermediary, also their compliances must also go hand in hand with the SPDI rules. So as a business policy, it must be ensured that that one complies with each and every regulation or rules which is emanated from the IT Act. So as a whole, one has to ensure that all the compliances are met. So to ensure that data protection is in place, properly is in place. Now we'll discuss about the consequences of not complying with the various provisions or various issues relating to the data protection. Now the IT Act lays down certain penalties if we don't comply to the issues relating to the data privacy and data protection. Section 43 prescribes the penalties, compensation and adjudication. Now, as per Section 43, if any person without the permission of the owner or any other person who is in charge of a computer system or computer network accesses to such computer or downloads or copies or extracts any computer data information from such computer, or introduces such computer in such computer any other virus which may hamper such information or damages the information, in such cases the penalty under Section 43 is attracted. Now in such scenarios, the person will be liable to pay damages as a compensation to an extent of 1 crore rupees to the persons who affected. So from section 43, we understand that how critical data protection and data privacy is in India. Now, giving a compensation of 1 crore is basically a very significant amount from a so in a situation where if any person from in an organization tampers with the data, so the cost which is incurred in actually paying off the penalty is huge. So from this we can understand how critical data protection or data privacy is. Now section 43A also prescribes compensation in case of failure to protect data. Now this, from the mere reading of the heading of 43A, triggers the fact that why privacy policies and proper privacy mechanisms is important for an organization to follow, because even failure to protect data will also attract penalty. Now, as 43A says that if a body corporate which is possessing or handling any sensitive personal data or information in a computer resource which it owns, controls, or operates, but is negligent in implementing and maintaining a proper and effective reasonable security practices, in such cases also, if any loss happens, if any wrongful loss happens to any other person, such body corporate has to pay damages by way of compensation, which may exceed till rupees 5 crores. Now this points out the fact and highlights the fact why it is so important to have a proper mechanism in place by organizations in relation to privacy policies and proper reasonable practices relating to personal data. Because even if the body corporate or a particular organization is not with intention hampering any data or resulting in dissemination of data to a wrongful hand, if by negligence also such issues happen or such incidents occur, it may result in payment of high penalties up to rupees 5 crores also. Now section 72A prescribes punishment for disclosure of information in breach of lawful contract. Now if I reiterate the provisions related to SPDI rules, in one of the provisions it said that prior consent from the provider of information needs to be taken. So when you are entering into a contract with a provider of information, you have a extra obligation on your plate to not to disseminate it without taking consent. Now, as section 72A prescribes that disclosure of information is required when you are entering into a lawful contract, even breach of such may also result to imprisonment or fine. Now section 72A says that in case of such scenarios, imprisonment may extend to 3 years or fine which may extend to 5 lakh rupees or both. So this also points out the fact that why data protection is such an important aspect in an organization. Now, how organizations need to implement this provisions under IT Act and allied IT rules and regulations, so that a proper mechanism or a proper system can be implemented. Now, IT Act requires an organization few things, such as no download of data without consent or disruption of computer systems, no handling sensitive personal data carefully, non-disclosure of personal information, and no alteration of computer source code. Now, whenever we have seen it in our practical day-to-day life working in an organization, that whenever we join a new organization, during the first few days of induction, we are told by the HR or the management that we are not allowed to take to mail the work related to the organization to our own personal IDs. So these are the ways, because this is ensured by the management of a particular organization, that all the sensitive data or the data which is critical for an business to operate, those information should not go to a third party. So even if you are mailing any information, or particularly your work in relation to such company, to your own personal mail also, that may also result in disseminating the information to a third party. So that is why the proper privacy policies of an organization is very important, so that everyone in an organization, right from the top management to the fresher in a particular company, has to ensure that the data of the company and the personal sensitive informations of an organization is well protected. The IT Act also requires that identification process that need to be in place to comply with the IT Act, to adhere to the decision control points to ensure compliance, and also continual audit of compliance processes. So audit of the compliances, or the frequent or the periodical audits of the IT compliances and the IT policies and the privacy policies also needs required to be carried out by an organization. Now, a comprehensive compliance management procedure of an organization includes accessible anytime and anywhere. This means that any network or any access to the network of an organization can be accessed from any location. But in such, so for example, your organization may have the facility of work from home, but even so you can access the particular data or particular information of the company from anywhere or from any location. But at the same time, one has to ensure that it is in compliance with the IT Act and the IT rules, and does not hamper or does not contravene any of the provisions. Now, to ensure that proper compliance is also done, assessment periodically needs to be undertaken, so that the data privacy protection laws are in tandem with the particular policies of an organization. Now we'll talk about the e-contracts. Now, what is e-con? Before delving into the matter of e-contracts, first we need to know what is a contract and from where the validity of e-contracts is emanating. Now, the Indian Contract Act 1872 governs the manner and execution of contracts in India. Now, the basic ingredients of a valid and legal contract includes offer and acceptance, the mutual consent of the parties, the intention to create a legal obligation through the contract, the free consent of the parties, and the parties must be competent to enter into the contract. Now, electronic contracts are nothing but the contracts in electronic format rather than the traditional paper format, which is, and the e-contracts have come into being because of the new fast era of technology. So to increase and to have a proper, convenient and efficient manner, and to enter into contracts and enter into business transactions in a lesser time, the e-contracts have been formulated. Now, in an electronic age, the conventional laws relating to contracts may not be sufficient to address the issues in e-contracts, because generally in the traditional or in the older times, when we used to enter into the normal traditional paper contracts, the problem of jurisdiction may not have arrived. For example, in e-contracts, I may be sitting in India, or I may be sitting in one state in India, and I may enter into a contract with a multinational company, and the contract which is entered into may be between places where I'm sitting in one state of India, and the company and the person on behalf of the company sitting in New York. So the jurisdictional issues come into play, especially in e-contracts. So in such situations, the existing regulations surrounding normal contracts may not address the problems. Now, the IT Act aims to address some of the issues that arise in the formation and authentication of e-contracts. Now, we'll discuss and see what are the issues. Now, IT Act acknowledges e-contracts through number of its provisions. Section 10A of the IT Act recognizes the validity of e-contracts. Now, as per Section 10A, a contract having all the essential elements, if a contract has all the essential elements such as offer and acceptance, consent, and legal obligation, consideration, all those elements if are present in a contract will not be considered as invalid only on the ground that the communication of proposal or the acceptance of the proposal or revocation was entered or done through in a e-format. So basically, Section 10A is the section validating the e-contracts. Now, according to Section 11, an electronic record will be attributed to the originator if it is sent by the originator himself or by a person who was given the authority to act on behalf of the originator, or by an information system programmed on or behalf of the originator to operate automatically. So this Section 11 of the IT Act basically talks about situations like, for example, an employee is working in an organization and the person is sending a mail which is related to, suppose the person is taking holiday for 2 or 3 days and using an auto-generated mail which is sent to the recipients of the mail. So situations like this have been acknowledged in Section 11 because an information system programmed by the originator which operates automatically also may result in formation of a contract. So if in situations like that is catered by Section 11. Now, what is an originator? Originator is defined under IT Act as a person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to another person. Now, Section 12 of IT Act provides how acknowledgement of receipt can be resulted in the formation of e-contract. Now, Section 12 can be divided into 3 parts. Now, Section 12.1 provides the methods in an e-contract through which acknowledgement of receipt of a record can be provided. Now, this can be provided through 2 methods, either automated or otherwise. So if one is using an automated auto-generated reply to any mail which is received by the person, for example, a lot of times we send a message to a particular recipient, and in lieu of that mail hits our inbox saying that the mail has been received. So in such situations, automated replies or automated acknowledgements may also result in e-contracts. Now, as per Section 12.2, if an originator has stipulated that electronic record is binding only on receipt of an acknowledgement, such electronic record will be deemed to have never sent by the originator unless the acknowledgement has been so received. So, for example, if a person wants that automated replies should not be considered as acceptance, the person has to expressly say that such automatic acknowledgement should not be considered as acceptance. Now, Section 12.3 says that in case the originator has not stipulated the electronic record will be binding on the receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed, such electronic record will be treated as if it was never have been sent. So these provisions points out the fact that even in e-contracts, since in e-contracts problems or issues relating to ambiguity or relation or situations like automated replies going out of the inbox, such may attract a lot of ambiguities and lot of conflicts. For example, if any automated reply goes to a person, and later on the person from whom the automated replies had gone denies the fact that I did not agree to such agreement, and um, take up the arguments that I had not accepted to the proposal of the contract. To cater to the problems and to solve those problems, these provisions have expressly provided that proper intention needs to be communicated to the other person in a particular contract. So even if we say that e-contracts have a lot of ambiguities and problems related to it, the act is not sufficiently saying or trying to solve the issues of ambiguities, we can see and read the provisions of IT Act, section 11 and 12. These provisions are providing that how one needs to take the safeguard, and the parties to a particular e-contract have to be in the same page through a proper communication between the two. Now, section 13 provides for the time and place of dispatch and recipient of e-contracts through electronic records. Now, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator. And an electronic record is deemed to be dispatched at the place where the originator has its place of business, and is deemed to be received at the place where the addressee has his place of business. And if the originator or the addressee has more than one place of business, the principal business will be considered as the place of business. Now, so the issues relating to if any litigation happens relating to a e-contract, the section 13 gives an answer of where the place of suit be, or where the which court will have the jurisdiction to take up the matters or take up the disputes relating to e-contract, because section 13 clearly says with what will be the place of business, or what will be the place of dispatch of the originator or the recipient of an e-contract. Now, digital signature is another issue in e-contracts. Now, whenever a contract is entered through an electronic mode, it is always necessary to establish the genuineness of the transaction to prove that the proposal was properly provided and the acceptance was also properly provided. Now, in normal traditional contracts, we use generally the acceptor and the acceptee, they give the signatures. Now, in e-contracts, this is done, and to prove the genuineness, for proving a genuineness in a particular situation, we generally see whether the signatures of the two parties are provided or not. Now, in e-contracts, this genuineness is provided through digital signatures. Now, in such signatures, that is why the parties to a contract requires to give its proper digital signature to prove the genuineness. Now, digital signature is basically an encryption of an electronic document which performs three important functions. That is, firstly, the security of the system, and to see the genuineness of the transaction, and to provide that the transaction is legally binding on the parties. Digital signature also ensures the data integrity, the data authentication, and prevention of any disowning of message by the receiver. So if a party to a contract is giving its digital signature, later on the party cannot shade away from its obligation, saying that I did not ascertain to such a contract. Now, the type of e-contracts which are present are, the first one is a browse wrap agreement. Now, in this type of agreement is binding on the contracting party by use of a website. Now, these websites are generally deemed to have a particular policy or particular terms and conditions which a person or a user or a visitor to the website has to agree on before entering and navigating such websites. So such kind of type of agreement is known as a browse wrap agreement. In shrink wrap agreement, there is a license agreement where the terms and conditions of the contracts are enforced on the consumer as soon as he opens the package. Now these type of contracts are we can see in case of software products. So when a software product or software is bought by a customer, before opening the package we see that there are a whole comprehensive terms and conditions are provided on the package. So it is ideally accepted that expected that before opening the package, if we read the agreements and the terms and conditions provided on the package and then we open it, that means we have read the party to the contract has read all the agreements, have given consent, and is on the same page with the proposer. And then when they have read the terms and conditions and opened the packages, that means they have entered into a contract. Now in case of shrink wrap agreement, the license agreement indemnifies the user for any copyright or intellectual property right violation as soon as the buyer opens the package containing the software product. Now the issue of shrink wrap agreements and the validity of such agreements first came up in a foreign judgment in Procode Incorporation versus Zeidenberg, where it was held that the very fact that the purchaser is reading the terms of the license or the terms and agreements outside the package, and after that opens the cover and uses the software, that shows and that reflects the fact that he have accepted the whole terms and conditions of license that appear on the screen, and opening the package and using the product shows that the person has entered into the agreement. Now the third type of agreement of third type of contract in an e-contract is click wrap or click-through agreements. Now this type of agreements requires the user to give his consent by clicking on onto the tab of OK or I agree button on the dialog box. So whenever we purchase any software through an e-commerce website, or we use the software just before, or we install any program or software in our computer, and before installing it we click into the I agree tab. That is the type of click wrap or click through agreements, where we read the terms and conditions, and by clicking the I agree tab we enter into a contract, and acceptance is also acknowledged. Now in such type of click wrap agreements, a user has the option to also disagree or reject the terms by clicking cancel or closing the window. And in case the user is rejecting by clicking the cancel, that means that the person is not accepting the terms and conditions and not entering into the contract. Now there is a difference between the shrink wrap and the click wrap agreement. Now unlike the shrink wrap agreements where the terms and conditions are hidden inside the box and it is provided on the package or the package of the product, in click wrap agreements all the terms and conditions are accessible prior to the acceptance, either through the window or through a hyperlink. Now the question of click wrap agreements also came up for consideration, and a validity was discussed in the case of Hotmail Corporation versus Van Money Pie Incorporation. Now the court in this case upheld the validity of the click wrap agreements by saying that when a person is clicking on the box containing I agree, he is bounded by the terms and agreements in the contract, and therefore by clicking to the option of I agree, the whole terms and conditions is legally binding on such person. Now, few problems relating to e-contracts and the challenges which have come time and again are many. One of the most important one is consensus ad item. Now, in contract, one of the foremost principles of a valid contract is that whether the parties are giving consent and giving the consent in the same and have and giving the consent with this in the having the same opinion on that issue. Now, in e-contracts, mostly we have seen for in practical purposes, whenever a person is using a software and has to mandatorily click I agree, if the person has to use a software, we hardly read the terms and conditions, or the terms and conditions are formulated by such software companies in such a way that even if by reading the contract or reading the terms and conditions, we hardly can comprehend the actual implications of accepting such terms and conditions. So the issue of consensus ad item, or actually giving a genuine consent, is often questioned in e-contracts. Now, so therefore, as discussed, now in e-contracts such as click wrap agreements, whenever the users enter into such agreements and click the I agree button to confirm his or her acceptance, there is no room for negotiation. It's like take it or leave it policy, which is used by such companies who are entering into the click wrap agreements. Now, since these contracts are basically adhesion contracts, that is, there is no room for negotiation, there is no room for bargaining. The question comes is, are the users genuinely giving the consent to use such contracts? Now, in Central Inland Water Corporation Limited versus Brojonath Ganguly and another, the Supreme Court of India had observed that in the most standardized agreements, also one of the parties actually don't have the bargaining power, and that is the problem which is there persistently present in e-contracts. Now, in contracts such as click wrap agreements, to ensure that this consensus ad item is properly maintained, it is given, or it is suggested by the Supreme Court, that proper care should be taken by the companies. Suppose the companies like Microsoft, where if we are buying a computer, it's obvious that we have to buy certain softwares from giant companies like Microsoft, and the terms and conditions which are formulated by them, even if a user don't like it, it has to accept the terms and conditions to use the computer along with the software. So in such scenarios, it is suggested by Supreme Court in the Central Inland Water Corporation that a proper care and proper standardized terms need to be formulated by these companies in an e-contract, so that it does not result in too much of advantage being meted out to one party at the cost of another. So it should be a pro-consumer or a pro, not too onerous on the consumer should be there in such in standardizing such terms and agreements in e-contracts. Now, the second issue relating to e-contracts are the consent, how it is given. Now, Contract Act 1872 does not require that the written contracts must be signed specifically. Therefore, for a contract to be valid and enforceable, each party is required to confirm its acceptance in any manner. So, any implied acceptance may also result in a valid contract, but the acceptance must be signified by some acts or agreements by the parties. Now, in such situation, the pertinent question might arise is, in e-contracts like click wrap or shrink wrap, is the consent properly given? Now, even though this issue is also burning issue in e-contracts, the Indian courts have not properly adjudicated or determine this particular issue of how consent is given or whether the consent given is actually valid or not. However, if we look into the various other judgments and judicial pronouncements of US courts, it has confirmed that by consenting to an agreement, by clicking into the I agree tab, the user is basically confirming his acceptance, and therefore any document or any assent given for that document should be held liable and accountable later on. But still the question is an open-ended question, and lot of controversies and lot of difference in opinion comes up when it comes to the question of whether valid consent is actually given or not. Now another issue in e-contract is stamping of e-contracts. Now under the Indian Stamp Act, no instrument is permitted to be submitted as an evidence in court of law unless it is duly stamped. Now the term instrument is defined under various stamp acts. For example, in Karnataka Stamp Act, an instrument is defined as every document and record created or maintained by an electronic storage and or any device which by any right or liability can be created, transferred, limited, extended, extinguished, or recorded. Also, in Bombay Stamp Act, the Bombay Stamp Act has also included electronic records into the term instrument and later on to an amendment in 2005. However, the problem is a mere instrument does not become subject to stamp duty. Now, if we look through the various judicial pronouncements, a document which is not signed is not liable to have stamp duty. Now in electronic contracts, the problem is the instrument is not signed as per the definitions of Indian Stamp Act or Indian Evidence Act. So if it is not signed, and through various judgments we have seen that a document which in a physical form needs a personal signature will be subject to stamp duty, and such instrument can at the end be taken as a evidence in a court of law. So if we look through the problem in e-contract is, if a e-contract is not subject to stamp duty, it cannot be taken as a evidence in law. So that is a big problem in e-contracts, that today if two parties so yeah, so hope I think we have discussed about the jurisdiction of courts, which was the second last slide in the presentation. Yeah. So I would like to recapitulate on the last slide where I was discussing about the various issues relating to the jurisdiction of courts in e-contracts. Now the issue is how to determine exactly what is the cause of action in a dispute relating to e-contracts where everything is happening on a virtual space. And this question has been taken up time and again by various courts in India. And in World Wrestling Entertainment Incorporation versus the Reshma Collection, the Delhi High Court had held that the principle which is governing the contracts or the oral contracts which are entered into through telephonic conversations will be taken up and will be applied equally in case of contracts which are executed over the internet. Now the Delhi court had further gone and said that in e-contracts, if the place from where the plaintiff has entered into such contracts, that place where the plaintiff resides or the place where the plaintiff's principal business or place of business is may also be taken as a place from where the cause of action would arise in case of e-contracts. Now, through these judicial pronouncements, the courts have tried to answer the jurisdictional issues relating to the courts in e-contracts or contracts happening through virtual space. Now, in concluding remarks, we can say that in order to see and implement that proper practice and proper process is in place to ensure that the data protection and the data privacy is properly maintained and properly complied by an organization, there are few actionables on part of an organization. The first one is to comply with the requirements stated in the various regulations and laws under IT Act, because as we have discussed in the presentation, the IT Act and the specific rules governing the personal sensitive information and the various data protection has been dealt in a properly and in a very stringent, in a very comprehensive way and in a very detailed manner in various rules and regulations under IT Act. So once an organization identifies its obligations, the due diligence it has to conduct under the regulations under IT Act, a proper policy or a proper mechanism to cater to privacy and data protection can be at place. The second stage will be proper assessment and regular audits seeing that the data protection laws are complied to. Also, one important thing which is required is to assess the risk associated with the violations happening, because as we go through the various penalty provisions under IT Act, the consequence of violations of data privacy or data protection is huge. Financially, the reputational costs that are incurred by an organization, and also the pecuniary problems or pecuniary obstructions which hampers the company's revenue from the financial perspective. So in such situations, compliance with the data protection and data privacy is really the need of an hour for an organization. Also, new processes with the changing law, with the changing upcoming issues, an organization also needs to have new processes to safeguard oneself from a non-compliance related to the IT Act and the IT issues. So regular checks and regular audits and regular assessments are important for running a business or running the business of an organization. Also, as an organization, one needs to have a dedicated source to check the internally control and handle all the possible or the potential problems that may happen relating to data protection or violation of data protection. So a proper process must be in place for the for an organization, because if we see the SPDI rules, it has clearly said, one of its provisions have clearly said that reasonable practice and measures needs to be taken by a body corporate to ensure that sensitive personal data is protected and it's not hampered or tampered with by any third person. So therefore, it is very important to for any organization, any company, any body corporate, and as individuals also, that the right to privacy which is given by our constitution and which is envisaged through the various acts and regulations relating to data protection is properly complied to and properly in place for an organization to prevent itself from all the reputational costs, all the controversies which surround which is revolving around any non-contravention of data protection or any illegal activities relating to data protection. So this is how, so this is the end of our presentation on this topic. So any questions regarding the same is invited.